Thank you very much. It's good to be here. For those of you who heard me talk, I don't know what I'm going to say either. So whatever the Spirit moves me. But we did talk about a lot of things last time, and there was some interest, and I wanted to revisit some of those issues. And it's interesting that most people in government haven't even read the Constitutions, much less study them and understand them. I've been doing this now for 24 years, and I've been asking the question of those in government for about 22 of those 24 years. Get a copy of the state constitution, give it to them, and say, and ask them if they've read it. Now, I can tell you that I preface that with, I've been studying it now 24 years, and maybe they're intimidated to a point where they're afraid about the next question I might ask. And so they usually say no. In 90 to 95% of the people that I've asked, the answer is no. That's a crime, isn't it? And anybody who's running for office, I would recommend that all of you get a copy of the state constitution. Now, this is the House version, and this is the Senate version. I can't get the Senate versions anymore. They've tried to reduce their budget, so I don't think they print as many, or either they just cut me off. But I can still get House versions at $100 a crack. And if you don't have any, there's some back there on the table. But you can get them from your representative and take them to the people who are in office and give it to them and ask them if they've read it. So there is a lot you can do. Now, when you do that, I'd really advise that you read it yourself first, particularly the Declaration of Rights. That's probably the most important part. And you can really instruct those who work for us to read the Declaration of Rights and understand that's what they can't do. Sort of like the Bill of Rights. That's a restriction, what they can't do. And Jim was talking about God's providence. And if you haven't read the Declaration of Independence recently, I'd encourage you to do that. And if you don't mind, I'm going to use the Senate version because it's bigger print and it only has the Constitution in it. But the preamble says, "We, the people of the Commonwealth of Pennsylvania, grateful to Almighty God for his blessings of civil and religious liberty, and humbly invoking his guidance, do ordain and establish this Constitution." End quote. Need I say any more? If you look at this, you will find that 46 of the 50 states have the same preamble. The others are very similar. And if you go back to the 1776 Constitution, it's even stronger, as Jim indicated. The very first sentence in the Constitution of 1776 is so powerful. It says, "Whereas all governments ought to be instituted and supported for the security and protection of the community as such." I had a politician who has to be an attorney over in Harrisburg say, "You see, that means that the government can do anything they want." Actually, it's referring to Article 1, Section 2, peace, safety, and happiness. That's why government's instituted. So that means government can do anything. But then I directed him to the rest of this introductory sentence. "And to ensure the individuals who compose it to enjoy the natural rights and the other blessings which the author of existence has bestowed upon man." Now, God's not in the government, right? No. And it goes on to say, "And wherever these great ends of government are not obtained, the people have a right, by common consent, to change it and take such measures as to them may appear necessary to promote their safety and happiness." It's in the Article 1, Section 2 still today. It hasn't changed. So God is in our Constitution, and of course everybody knew in 1776 what God we were talking about. It's God, Jesus Christ, and the Holy Ghost. And that's it. Now, it doesn't mean that you can't believe in something else. It's just that our government is based on the principles found in the Bible, Old and New Testament. And no one can deny that if they just pick up a book and read some of the early documents. So I won't dwell on that tonight because we talked a little bit about that before. What I'd like to talk about today is something, as it turns out, is pretty timely. Because today I was listening to Mark Levin. By the way, I'll address Mark Levin's book here in a minute. But point being is, he's a Harvard graduate attorney, and among other things, brilliant man, has his own radio show. And he was talking about the 14th Amendment being used by the current man in the White House to raise the debt ceiling. So I had intended to talk about the 14th Amendment, and that's sort of pertinent. So how many of you know what the 14th Amendment is? It was allegedly ratified in July of 1868. I say allegedly because I'm going to show you why it doesn't exist. Now, amending the Constitution is a very detailed process, isn't it? And the framers did that intentionally. The same with the Pennsylvania Constitution. And they didn't intend to have it changed just sporadically or on a whim. That's why it's so difficult. So, what does the 14th Amendment say? First of all, it says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state in which they reside. The first sentence. It goes on to say, no state shall, and if you want to read it, you can. I want to focus on that first part. And then I want to jump down and look at the fourth section, which says, the validity of the public debt of the United States authorized by law, including debts incurred for payments of pensions and bounties for service in supporting in suppressing insurrection and or rebellion, shall not be questioned. Now, the perversion of what the Constitution means is so pervasive, but maybe it doesn't matter. When we get done tonight, maybe you'll say it doesn't really matter what the 14th Amendment says. And why would I say that? Because there is a specific and well-defined way of amending the Constitution. It's in Article 5 of the Constitution, and I'll paraphrase it. I could read it, and I would recommend that you do read it. But there are a couple ways to amend the Constitution, aren't there? The federal Constitution. The Congress can propose an amendment and vote on it, 2/3 of each house, or the legislatures of the states can propose it, and 2/3 of them do that in conventions. The ratification process then, once that occurs, and each house has to do it, then it's sent out to the states for ratification. And originally 9, but 3/4 of the states must ratify it. Either the legislature or conventions of the people of the states. Those are the two methods allowed. Once that occurs, that change, if it's followed precisely, and nothing's changed during the ratification process, as an example, not one comma, then it automatically becomes part of the Constitution. There's no action required by the Congress, nor the President, or anyone else. All that's required, originally used to be the Secretary of State, to declare that the 3/4 requirement was met and that it has become part of the Constitution. Now, keeping that in mind, let's look at what happened with respect to the 14th Amendment. First of all, I'd like to introduce you to a couple documents. And I was doing my research in the law library, and I found these documents, and then I discovered, have you ever heard of the Citizens Rule Book? Well, I have a version called The Supreme Law of the Land that Dr. Nichols did years ago. I'm just about out of them, unfortunately. But in this document, it also reveals these 5 documents that I'm going to share with you right now. In 1975, there was a case in Utah, and the Justice of the Supreme Court, Ellett, of the Utah Supreme Court, in the case of State of Utah versus Kemp Phillips, stated this: The dissenting opinion asserts that, quote, the 14th Amendment is part of the Constitution of the United States, end quote. While this same assertion has been made by the United States Supreme Court, that court has never held that the amendment was legally adopted. I cannot believe that any court in full possession of its faculties could honestly hold that the amendment was properly approved and adopted. This is a justice of the Utah Supreme Court. You don't have to make any of this up. It's really great. Well, he cited then at the end of that quote an earlier case, which he did in 1967, Diet versus Turner, which is 20 Utah 2nd 403. It's a 1968 case. And I'll come back to that in a minute. There's also a 1953 Tulane Law Review article, 28. The title of that article, written by an attorney, is The Dubious Origin of the 14th Amendment. Fascinating. In 1959, the South Carolina Law Quarterly, Volume 11, had this article, said, the 14th Amendment to the Constitution for the United States and the threat that it poses to our democratic government, end quote. Now, in 1953, I think we were, at best, a democracy. We've moved on from that point, in my opinion. But that was the article. And then in 1967, they also had this in the June 13th entry in the Congressional Record. Quote, the 14th Amendment, equal protection or tool of usurpation. So there's a lot of evidence. Now, this is just a little of it. There's a lot of it. You can, in fact, spend your life on the internet and in the law library reading it. So there's a lot of people, not just me, who are saying to you, this amendment that we are really saddled with was never properly approved or ratified. And you know the principle of the law that if something is unconstitutional, it's null and void from the time that it was done. Everybody goes to Marver versus Madison and 1803 case, allegedly saying, well, that gives all the power to the courts. By the way, it doesn't say that. That's a deception by certain attorneys and judges and professors of law. But Marbury versus Madison doesn't claim that. And in fact, it says that anything contrary to the Constitution, anything that abrogates the Constitution is null and void. There are multiple decisions that confirm that. In fact, Alexander Hamilton in Federal 78, if you haven't read that, confirms it as well. Anything that's contrary to the Constitution is null and void. The question then becomes, who can determine it? Now, the attorneys and judges will tell you, only the courts. Wrong. Who's the sovereign in this country? We are. Unique on the earth. Sovereignty is the ultimate authority. Now, we all know that the ultimate authority, God, Jesus Christ and the Holy Spirit or Ghost, is the ultimate sovereign, isn't he? He's the creator of us. And anything that's created is always inferior to the creator, isn't it? So, when the states created the central government, the conventions of the states, who is the superior party to that agreement? The states are the superior party. And because the states became part of the Union after it was ratified, right, started as a piece of paper on September 17th, 1787. It left Philadelphia and went out to the states to be ratified. It was a great document on parchment, but it was just that. It was just a document then, wasn't it? It was not law. And the requirement was that 3/4 of the states would have to ratify it. New Hampshire ratified that document on June 21st, 1788. It became law that day. It didn't go into force until October 4th, 1789. That's not correct. March 4th. March 4th, 1789. And so it became, that was when the first Congress assembled in New York, actually, where it was, and the Constitution went in force. And one of the things that disturbed those who were ratifying was there was no Bill of Rights. And Hamilton had argued, you don't need the Bill of Rights. Others did too. Because the states have declaration of rights, and the central government, the federal government, is not going to do much with respect to the people, so that's not really necessary. The other argument was, well, if we put down some rights, that'll say that the rest of them don't exist. Another bad argument. And so you may remember that the 9th Amendment of the Bill of Rights reads as follows, quote, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people," end quote. That was specifically put in there to address Hamilton's concerns. We have a lot of rights besides those of which are enumerated in the Bill of Rights. Now, the 10th Amendment was there to satisfy the other concern. The 10th Amendment reads, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people." Fathom what that says? The Constitution specifically enumerated limited powers. And if it's not in there, the central government, that is the federal government, or any central government for that matter, in this country, has no authority to even talk about it, much less do anything about it. Now today, you know that they do a lot of that, don't they? But the Constitution says, no, if it's not enumerated, specifically, you have no authority to act on it. So when you understand that, you say, wait a minute, where in the Constitution is authority to talk about insurance or health care? Not there. Now, what does that mean? It means Obamacare is unconstitutional. And it doesn't matter what the courts pronounce. That's the most ridiculous opinion I've ever heard. You know, get taxed for doing nothing? I have a paper on the website, and by the way, I would encourage you to read a lot that's on there, and there are copies of them, some of them over there on the table. It's sheriffbrigadesofpenn.com, and I'm going to hand out a paper, or you can get it over at the table rather, that has that website on it. 6 reasons why the Obamacare decision is unconstitutional. 6. I have an earlier paper that says why Obamacare is unconstitutional, period, because primarily there's no authority for the federal government, the central government, to even act on the subject matter. And we're protected by the Bill of Rights to that effect. Well, the 14th Amendment is another one of those situations which is unconstitutional. Now, one of the best advice I got, and this was when I first started doing this in the early 90s, I talked with a fellow in Pensacola, Florida, for over an hour, almost an hour and a half. And we stopped and he said, "Now, Bill, don't do anything that we've talked about today." So I said, "What have we been talking for an hour and a half for?" And then he finished his thought. He said, "Unless you understand it, believe in it, and are prepared to defend it." Probably the best advice I ever got. Because if you're going to take on the government, they don't like that. It's sort of like the founders, when they took on the strongest power on the world, they hid behind trees and rocks and fences, rock walls, and they had long rifles. And the English, being so arrogant, I guess, walked down the middle of the road in red coats. Not too bright. So they became good targets. Point being is, they were prepared to stand up for what they believed, weren't they? They put their life on the line. In fact, the Declaration of Independence says, relying on divine providence, 4 times God is mentioned in the Declaration of Independence, and we learned in the Pennsylvania Constitution God is mentioned. Everybody says, well, God's not in the Constitution. Oh, yes, he is. Through the Declaration of Independence, if nothing else. But What did they do in the Declaration of Independence? They pledged their lives, their fortunes, and their sacred honor, didn't they? At the end of the day, I think that's what we have to do. If we don't do it, just like Jim says, we lose. Well, here's a scholar on the Constitution. I like Cooley. Judge Cooley was from Michigan, but he wrote extensively on the Constitution. And this book, very small book, was originally written in 1880. It was republished in 1896. But in the preface to this book, it's amazing, absolutely amazing what he says. I can find it. Got ahead of myself here. There are a lot of scholars, by the way, and I'd recommend that you start, if you really want to understand the Constitution, you read what they have written, because they grew up with it, all right? And it was before it got changed so drastically. Here's what it says in the preface. This manual, the manual which follows has been prepared for the use of students in law schools and other institutions of learning. It's a law book. The design has been to present succinctly the general principles of constitutional law, whether they pertain to the federal system or to the state system or to both. Formerly, the structure of the federal constitution of government was so distinct from that of the states that each might usefully be examined and discussed apart from the other. But the points of contact and dependence have been so largely increased by the recent amendments to the federal Constitution that a different course is now deemed advisable. 1880, what were the changes? The 13th Amendment, the Slavery Amendment, the 14th Amendment. The Slavery Amendment was done in 65, the so-called 14th Amendment in 68, and the 15th in 1870. Those are the constitutional amendments he's talking about. So what so drastically changed? I read that the 14th Amendment starts out by saying, what? All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state in which they reside. Prior to this, you were a citizen of the state, Pennsylvania. And because Pennsylvania was a state in the Union, you were also a citizen of the United States. You were first and foremost a Pennsylvanian. Now, the central government didn't like that, did they? In fact, during the whole process of ratification and the development of the Constitution, the Federalists wanted a European-style central government, didn't they? Hamilton was a tremendous advocate of that, as were others. The anti-Federalists, like Jefferson, said, no, states are superior. Well, in the convention, they lost the principle that they were going to have a European-style government. The states retained most things. That's what the 10th Amendment confirms, doesn't it? And that there's a limited, delegated authority. Article 1, Section 8 gives you 17 powers that the Congress has. There's a few others scattered throughout, about 25 altogether in the Constitution that the federal government could do, and that's it. The states retain most. And they also retain the fact that the states were members of the compact, and because they created it by natural law, they were superior to the central government. They did things in the federal Constitution for very specific reasons. Like the Second Amendment. Everybody wants, Second Amendment rights. Well, there's no such thing as a Second Amendment right. You have the right to keep and bear arms, don't you? Well, that's in the Pennsylvania Constitution, always has been. It's Article 1, Section 21. It says the right of the citizens to bear arms in defense of themselves and the state shall not be questioned. Anything unclear about that? Infringe is the same thing. It was a compromise word, but it means the same thing. And why did they put those in the constitutions? Well, in 1776, they were in the midst of a war with the greatest power on earth, the British Empire, weren't they? And history proves that the first thing that a tyrant does is take away the ability of the citizens to defend themselves. They take away their arms. And the framers said, nope. Nobody in government has the authority to question our right to keep and bear arms, any arms that the government has. Any arms. Now, the federal government had put that in the Constitution because in the federal jurisdiction, just like they said, hey, we don't want to ratify this unless the federal jurisdiction is also protected, our rights are protected in that jurisdiction. Those be two separate, all right? And so the Second Amendment says the same thing. Well, think about this. What weapons did they have then? They had swords and knives and bayonets, and pistols, muskets, and rifles, and cannons. That's it. And if you look at history, all the colonists had all those weapons, and that cannon that was part of this in the center of the town, that was owned by somebody. It wasn't a community property. And they had drilling and so forth. Usually after church, by the way, the pastor would preach in the morning and drill the militia in the afternoon. At any rate, what was happening when they were marching on Lexington and Concord? That is the British. They were going to get the weapons that were kept there. And the colonists moved them so they didn't get them. So when they wrote the Constitution, both state and federal, talking about the right to bear arms, they knew that they could have any weapon that the government had. Because why were those provisions put in there? It wasn't hunting and target shooting. No. It wasn't, well, maybe it depends on who you're hunting. But anyway, the point being is, it was to protect us against tyrannical government. That's the only reason. It's a God-given right. You can defend your life and your family and your property. And the way to do that is with the weapons that they have. You would never go to a gunfight with a knife. That makes no sense. And neither would the colonists. So today, whether the powers to be say otherwise, you and I have the right, the protected right, to keep and bear arms, any arms that the military has, including an atomic bomb. Now, that might be a bit radical. I wouldn't want one because you have to be responsible. You can't just sit it out in the backyard and say, oh, that's neat, all right? You got to secure it. I do have a paper on there. I got upset with Justice Scalia when he was addressing this. He was in an interview with Mike Wallace, and he was talking about Obamacare initially, but it got onto the right to bear arms, and he says, well, that means anything you can carry. I said, wait a minute. You're supposed to be an original intent guy. I lost a lot of respect for him that day. So he said, well, it doesn't include a cannon, and we'll have to deal with this shoulder-mounted rockets when that comes in front of us. And right then I said, man, I just thought you were an original intent guy, and you're not. So I wrote, the right to bear arms is a God-given right. And you can read my paper on the website. I take him to task. There's nobody that should be free from being taken to task in government. Do you know that? That's your right. I've distracted myself, but I think I would be remiss if I didn't point this out. In Article 1, Section 7 of the Pennsylvania Constitution, the title of it is Freedom of Press and Speech and Libels. You need to get this out. This is so powerful. The printing press shall be free to every person who may undertake to examine the proceedings of the legislature or any branch of government. Oh, no, that's just for these established printing folks, right? The news media. No, it's yours and my right. Every person. And no law shall ever be made to restrain the right thereof. That's pretty specific. Can they tell you not to write on something? Well, there's some exceptions, so let's read on. The free communication of thoughts and opinions is one of the invaluable rights of man, and every citizen may freely speak, write, and print on any subject, being responsible for the abuse of that liberty. No conviction shall be had in any prosecution for publications of papers relating to the official conduct of officers or men in public capacity, or to any other matter proper for public investigation or information, where the facts that such publication was not maliciously or negligently made shall be established to the satisfaction of the jury. And in all indictments for libel, the jury shall have the right to determine the law and the facts under the direction of the court, as in other cases. Uh-oh, what do you hear today? Oh my goodness, the judge tells you what the law is. The jury can only determine the facts. Another lie. That just says that. Well, in the House version, they got a case cited, which, by the way, it's amazing. The state Supreme Court determined that last sentence was unconstitutional. How in the world can the Supreme Court of this state determine anything the Constitution is unconstitutional? They can't. All right? Well, they base it on the United States Supreme Court, which, by the way, doesn't touch on the subject either. So the bottom line is they just wanted to eliminate that and let us believe that you don't have that right. And they put that case in the Constitution. How can you do that? When I complained about it to the Speaker of the House a number of years ago, he said, well, it's helpful. And I said, fine, write another book. It's not part of the Constitution. Anyway, there's a lot of these things that governments do and people in government who are ignorant of it. And it's our job as the sovereigns, as the boss, to explain to those what their job is, isn't it? We've been lazy. We haven't done our homework. The 14th Amendment is no exception. This amendment is used extensively. I told you about Diet versus Turner. Let me read the introduction that Justice Ellett did. I wish judges would write this way more often. This is Justice Ellett in Diet versus Turner's 20 Utah 2nd, 403, 1967. Quote, the United States Supreme Court, as at present constituted, has departed from the Constitution as it has been interpreted from its inception, and has followed the urgings of social reformers in fostering upon this nation laws which even Congress could not constitutionally pass. It has amended the Constitution in a manner unknown to the document itself. While it takes 3/4 of the states of the Union to change the Constitution legally, yet as few as 5 men who have never been elected to office can by judicial fiat accomplish a change just as radical as could 3/4 of the states of this nation. As a result of the recent holdings of the court, the sovereignty of the states, in particular, is practically abolished. And while free and independent states are now, in effect and purpose, merely close supervised units in the federal system. 1967, folks. We do not believe that justices of once free and independent states should surrender their constitutional powers without being heard from. We would betray the trust of our people if we sat sublimely by and permitted the great bulk of our powers to be taken over by the federal courts without at least stating reasons why it should not be done. By attempting to save the dual relationship which has henceforth existed between state and federal authority, and which is clearly set out in the Constitution, we think we act in the best interest of our country. We feel like galley slaves of old. We feel like galley slaves chained to our oars by the powers from which we cannot free ourselves. But like slaves of old, we think we must cry out when we can see the boat heading into the maelstrom directly ahead of us. And by doing so, we hope that the master of the craft will heed our calls and avert the dangers which confront us all. But by raising our voices in protest, we, like the galley slaves of old, expect to be lashed for doing so. We are confident that we will not be struck by 90% of the people of this nation who long for the return to the days when the Constitution was a document plain enough to be understood by all who read it, the meaning of which was set firmly like a jewel in the matrix of common sense and wise judicial decisions. We shall not complain if those who berate us belong to that small group who refuse to take an oath that they will not overthrow this government by force. When we bare our legal backs to receive these verbal lashes, we will try to be brave, and should the great court of these United States decide that in our thinking we have committed error, then we shall indeed feel honored, for we will then be placed in equal footing with all those great justices who at this late date are also said to have been in error for so many years, end quote. That's an introduction to what he wrote in Diet versus Turner as to what happened with the 14th Amendment. Now, I'd like to spend a little time telling you a summary of what that was. You can read all of it online. In fact, there's a list of websites that you can go read the original documents. You can read the one I was reading from, a summary, but you can read all the original documents. It's all online. So what happened? Just to show you that when the court said, that Elliott said when he didn't think that it had been properly approved or ratified, right? Here's what happened. Remember that the war between the states is over, and they in fact had ratified the 13th Amendment. That's the slavery amendment. The southern states had been involved in the ratification of that amendment. Well, the northerners were upset with the southerners, so they're going to teach them a lesson. So they wrote and rewrote the so-called 14th Amendment until it sounded good. And they tried to get it passed through the House. Well, they had, in fact, not allowed 10 of the southern states to be represented in the Congress. But even then, the House needed 122 votes to get the 2/3. They only got 120. But a lot abstained, so they said, okay, that's all right. Then it went to the Senate. The Senate needed 34 votes with the ones of the states that were represented at the time. All the states weren't represented, but of the states that were represented, they needed 34 votes. They only had 33. So in their infinite wisdom, in this crisis time, they said the senator, John P. Stockton, had only been elected by a plurality, not a majority, in New Jersey. Don't the states set up how the votes are taken, even today? They control what's determined, who wins. And that's was the case then. But no, in their infinite wisdom, they said he only won by a plurality, so we're going to throw him out. Now, he was already seated in the Senate. Was that constitutional? Well, of course not. But they did it, and then they had 33, and it passed. All right? That's why he said it wasn't properly approved. Now let's go to the ratification process. This even gets more interesting. They sent it out to the states to be ratified. And the southern states said, wait a minute, this is not right. And so they voted against it, 11 of them. Well, Tennessee changed its vote, so 10 of them. Well, it was dead on arrival because they could never get 3/4 of the states. There were 37 states at the time, with 10 of them rejecting it, could never pass. So Seward, who was the Secretary of the State, started to write that up. Now remember, the Congress neither has any authority here. So Seward writes it up, and the Congress said, don't do that. No, don't write it up. And then they did what was called the Reconstruction Act. Maybe some of you remember that. They took over the South. They created 5 military zones, 2 states in each one, under martial law. And one of the conditions to get back in the Union was to ratify the 14th Amendment. Under martial law. They also threw out the legislatures of the states. They put in their own. They gave all sorts of deals to people so they'd vote the right way. A crisis did not get wasted, did it, Mr. Man? Anyway. So then what happened? So eventually, 7 of the 10 states acquiesced. So then they went to count the number. And wait a minute, they didn't have enough then because some of the states had changed their mind, like New Jersey. He said, no. California had not voted, and they voted against it. Oregon, interestingly enough, had an election, but it was done improperly. And so they had to have a recall of it was very close, one vote. And the person who voted for it was not reelected. The one that got elected voted against it, so it was reversed. So there weren't enough states then to pass it. So Stewart's ready to write that up. Failed, right? And Congress says, oh, no, don't do that. Don't do that. You count the ones that were yeas before and the ones that are yeas now and say it passed. Well, under duress, he did that. And so, allegedly, on July 28th, 1868, it became part of the Constitution. Now, if anybody sitting in this audience believes that that is lawful according to the provisions of Article 5, I got a bridge I'd like to sell you. It goes over here to Jersey, right? So the point being is, there is concrete evidence that that amendment was never properly approved or ratified. Now, why am I spending so much time talking about this? Right? Old history. It's been around for so long. Judge Bork said, we've done so much with the 14th Amendment, it's too late to change it. Wait a minute. If it's unconstitutional, it's null and void from the time they did it. Right? That's a matter of law. Why is that important? Because everything that goes from the state to the central government, where they have no authority, is through the 14th Amendment. You concerned about Roe versus Wade? That was a case created by an attorney in Texas with a lady who went along. She subsequently renounced it, didn't she? And so it got taken to the Supreme Court through the 14th Amendment, and they spent most of that decision determining when life began. Most of that opinion. And they quoted not only quote-unquote authorities here, but overseas, and on and on. And they determined, because no one else had ever determined when life begins. Wait a minute, just read the Bible, folks. All right? But never, in fact, I'm writing a paper, Life Begins Before Conception. Let's push it. Doesn't it? Those little dudes are swimming around all by themselves. Right? They got to be alive. At any rate, human life begins at conception. Point being is, they didn't have the technology to prove that then. And so they made the determination that life begins in the 3rd trimester. Arbitrary and capricious, absolutely, because nobody else had ever decided it. Well, now, we have technology. God has given us technology that can prove exactly that it begins at conception. So there is no debate. And even there was a debate, the court had no authority to make a decision because it came from Texas over a matter which the federal government has no jurisdiction. They have no authority over life or death, for that matter. So, it's null and void, isn't it? All you got to do is say, no, I don't recognize it. And as a sovereign, you have the authority to do that. That's true with others. And by the way, everything that flows from that decision wasn't legislated, was it? It was the courts. Do they have the authority to make law? No. Of course not. I have a paper on that, no such thing as case law. If you'd like a copy of it, I'll dig it out. It's also online, and I'll be glad to give you one for your wife. Because I hope when she becomes the district attorney, she'll take that to heart. Point being is, the courts have no authority to make law. They make decisions and opinions. Is that law? No. In fact, Justice Story confirmed that. And I wrote this in the paper. I talk about how it got changed in a couple paragraphs. But close it out by this with Justice Story. Now, Justice Story is an interesting person. He also has written a great deal of constitutional commentaries and other works. He was 10 in 1789. He served in the Massachusetts General Assembly. He served in the Congress. He was on the Supreme Court of the United States from 1811 to 1845 when he died. Don't you think he sort of knew what was going on? Better than those who go around today. Even Scalia. I'm disappointed. But he wrote the unanimous decision in a case called Swift versus Tyson. It's 16 Peter, which I think equates to 41 U.S., 16 Peter 1, and this quote is on 18, and it's an 1842 case. So it's sort of late in his service. And they were looking at the word law in the Judicial Act of 1789. What is the meaning of law? And trying to see whether court decisions were law. And here's what he wrote as a unanimous decision. In the ordinary use of language, it will hardly be contended that the decision of courts constitute laws. They are, at most, only evidence of what the laws are and are not, and not of themselves laws, end quote. That's absolutely true, isn't it? If it's constitutional and it's properly applied, then the parties of that case, the holding in that case, applies to the parties of the case, the law of the case, and the facts of the case. It's instructive to the rest of us. If it's not constitutional or it's misapplied, it doesn't exist. Right? Anything unconstitutional is null and void from the time he did it. And that's what he's saying. If, in fact, it's constitutional, then it might be instructive, but it is not binding on anybody except the parties of the case, with respect to the facts of the case and the law of that case. Now, attorneys might differ with that opinion. Well, it's not really opinion. It's stated. It's actually fact. And it's the law. And I had a judge tell me when I was quoting this in a case in front of him, he said, well, that's a real old case. Of course, they don't think anything before 1933 is valid. So I said, well, the first time I read this was Erie Railroad versus Tompkins in 1937. Took that argument right up from him. He said, okay. Anyway, the point being is, knowing that, you can say, wait a minute, what do you think you're doing here? The 14th Amendment is so unconstitutional, it's evident to you, isn't it? Based on what I told you. Now, don't believe me. Do what my friend from Pensacola said. Go check it out. Read it for yourself. I've given you 5 references. You can get it on the internet and spend the rest of your life talking about the 14th Amendment. This is how pervasive it is, because it's so important. It, in fact, has been used to give the central government, now the national government at best, power to come into the states. There's the case 1947, Adamson versus California. In a dissenting opinion, they said that the first 8 articles of the Bill of Rights applied within the states, gave the federal government jurisdiction within the states. In a dissenting opinion. And then they just started doing it. Couldn't be. The state has a Declaration of Rights, which came in Pennsylvania, was there before there was a United States government. Right? So we're really on solid ground. We have a rich history of law and facts on our side here. The 14th Amendment doesn't exist. What did Judge Perez say in the congressional record with respect to this, which I think is extremely instructive? This was in 1967. 1967. And what they were trying to do was get the Congress to send this out to all the states to have them declare that the so-called 14th Amendment was unconstitutional because the courts weren't doing it. All right? They were trying to get what? Oh, the states to nullify the 14th Amendment. How many of you know about nullification? Another trip back, maybe. Anyway, point being is, what did they say? It should need no further citations to sustain the proposition that neither the joint resolution proposing the 14th Amendment nor its ratification by the required 3/4 of the states in the Union were in compliance with the requirements of Article 5 of the Constitution. When the mandatory, listen very closely to this, when the mandatory provisions of the Constitution are violated, the Constitution itself strikes with nullity the act which does violence to its provisions. Let me read that again. When the mandatory provisions of the Constitution are violated, the Constitution itself strikes with nullity the act that does violence to its provisions. You need no repeal. You need no other action of anybody. The Constitution and those who take their oath are required to say it doesn't exist at every level. The Congress is violating their oath of office by letting Obamacare live one day. They should have never taken it up. It violates the Constitution repeatedly. It is null and void on its face. And anybody wants to debate that, let's dance. Anyway, the point being is, thus the Constitution strikes with nullity the purported 14th Amendment. The courts, bound by oath to support the Constitution, should review all of the evidence herein submitted and measure the facts proving violations of the mandatory provisions of the Constitution with Article 5, and finally render judgment declaring said purported amendment never to have been adopted as required by the Constitution. This is a justice of the Louisiana Supreme Court writing this. And as Chief Justice Marshall pointed out in the unanimous court in Marbury v. Madison, 1 Cranch 138 at 173, it was an 1803 case, quote, the framers of the Constitution contemplated the instrument as a rule for the government of courts as well as the legislature. Why does a judge swear to discharge his duties agreeable to the Constitution of the United States if that Constitution forms no rule for his government? If such be the real state of things, that is worse than solemn mockery. To prescribe or take an oath becomes equally a crime. Violate your oath, it's a crime. I'll come back to that in a minute. Thus, the particular phraseology in the Constitution of the United States confirms and strengthens the principles supposed to be essential to all written Constitution. Courts, as well as all other departments, are bound by that instrument. That's in Marbury versus Madison, 1803. And everybody says, well, that gives the Supreme Court the ability to determine everything. No, everybody in government is bound by their oath. And when they violate it, they commit felonies. This is how strong this is. The federal courts, now Perez speaking again, the federal courts actually refuse to hear argument on the invalidity of the 14th Amendment, even when the issue is presented squarely by the pleadings and evidence as above. And they had gone through this long evidence that appears in other documents. This is so pertinent. 1967, they're saying this. Now listen to what he said. Only an aroused public sentiment in favor of preserving the Constitution and our instruments and freedoms under constitutional government and the future security of our country will break the political barriers which now prevent judicial consideration on the unconstitutionality of the 14th Amendment. You were reading about 1984. This is 1967. And we're still waiting around for the courts to decide this. We don't have to wait. Learn about nullification. Stand up and say no. Justice Bork confirmed that the 14th Amendment was unconstitutional. Of course, you know what happened to Justice Bork. He got borked, didn't he? Anyway, he said, but, as I said earlier, we've done so much based on it, it's too late to change it. Bull. You build a house on sand and what happens? It falls down. Guess what? Our house, our country, is falling down around us because of this amendment, alleged amendment, and the 16th and the 17th, which were also not done constitutionally. The 16th, the work done there was Bill Benson and Red Beckman, 2-volume large books, The Law That Never Was, documented the fact that the states didn't ratify it according to the requirements. The 17th Amendment, likewise, not done. What did the 17th Amendment do? Eliminated the senators being placed in in Washington by the legislatures of the states. So the states were represented in the central government. Their interests were, in fact, protected, which it was supposed to be because we have a union of independent states, don't we? Oh, we're supposed to anyway. All right? And the senators were there to protect those interests of the states, the superior party to the compact, other than the people, clearly. Remember the 10th Amendment? Reserved to the states respectively or to the people. We've lost our government, and we lost our government a long time ago. We lost it, actually, in 1861. Lincoln was not an evil man. He was surrounded by a lot of evil men. And the idea, well, he got murdered, didn't he? Don't have to go into that now. But this amendment was passed after that, this 14th Amendment, and it converted the relationship of the states and the central government. And it starts out by saying, you're a citizen of the United States and citizen of the state in which you reside. And it also starts out by saying all persons born or naturalized. And the reason you can do partial birth abortions, because the definition of being born is the child has to be separate from the mother. The child can be on the umbilical cord, but it has to be totally separate from the mother to be born. That's the definition. So what do? You turn the baby around, bring it out backwards, leave the head inside, stick a pair of scissors, and murder it. Partial birth abortion. Abomination, isn't it? All murder is murder, and that is certainly murder. And as I have proven, I think, without the 14th Amendment, the feds couldn't get involved. And I don't know if any legislation has been done to say that they can do these abortions. It's all based on Roe versus Wade, isn't it? 5 men in dresses saying, you can't do this. How much time do I have? About it? All right, let me close by saying this. And I would like to take a few questions, if I may. Yep. All right. I think we can learn from Patrick Henry. How many of you remember give me liberty or give me death? Do you know where that came from? He first said that when he was riding through Culpeper, Virginia, and he saw a man lashed to a pole being whipped mercilessly. And he stopped and asked an onlooker why he was being scourged so fiercely. And the onlooker told him and said, he's a pastor, and he has refused to take a license to preach. The Royalists wanted the pastors to be under the control of the crown, so they wouldn't be leading the Black Road Brigade in the War for Independence. But that statement is not just give me liberty, give me death. The last phrase of it is this: it is in vain, sir, to extemporate the matter. Gentlemen may cry, peace, peace, but there is no peace. The war is actually begun. The next gale that sweeps from the north will bring to our ears the clash of resounding arms. Our brethren are already in the fields. Why stand we here idle? What is it that gentlemen wish? What would they have? Is life so dear or peace so sweet as to be purchased at the price of chains and slavery? Forbid it, Almighty God. I know not what course others may take, but as for me, give me liberty or give me death. If you haven't read his entire speech, I recommend that you do it. It's online. But that is where we are right now, in my opinion. We really need to pledge our lives and our fortunes and our sacred honor, and there's a lot of things we can do. So I thank you for your attention. Are there any questions? I'll wear you out. Yes, sir.
If I, as a citizen, basically call a particular involved
Unfortunately, if those in government and the police are there, you've got to ask the police whether they've read the Constitution. Give them a copy. They took an oath to support, obey, and defend it, by the way. It's on file. That they haven't, and they're not taught. Neither are district magistrates, neither are attorneys. They don't study them either. They study cases and procedures. Very rarely does an attorney read the Constitution, state or federal. So when you, in fact, say to somebody who has a gun and a badge, and they've been brainwashed their whole lives, you can't do that. Well, it's been my experience, and by the way, I've had a lot of experience talking to police officers on this very subject. They will try to talk you out of it. Try to tell you, no, you don't have that. You got to do what I tell you, so on, without question. If you don't, they go to force. That's what they're taught. And they call their buddies, and they come. It's the standing army, isn't it? Shoom! And they descend upon you and take you to the ground and teach you that they're the boss. But guess what? Beat you up as they may, throw you in prison, you still can go to court and at least tie the court up for a long, long time. Make them prove everything. They generally have no authority. Sometimes you'll win, depending on whether you have a jury or you have a judge that has a conscience. I think a lot of judges, frankly, enjoy having somebody like me come because they really have a dull life, don't they? They got the script, you do this, to do, and yes, you're guilty, all right? Or maybe you code plead and you get out. You get out from it. But it's really routine. And then somebody who comes and says, wait a minute, did you read this document? You had no authority to do that to me. And by the way, the police officer is the outlaw, not me. Now that's sort of entertaining to some judges, and they'll entertain it. You might lose anyway, all right? They got to pay the bills. That's what it's all about. Collect the revenue, throw you in jail, whatever they got to do. But at least you brighten up a judge's day, or you can have a jury that you educate, but you're certainly going to educate a whole bunch of people in the courtroom, all right? And you can do that. Do it all the time. I tried to get 100 people in each county, that's 6,700 people in Pennsylvania, in the 90s, to do what I do. Challenge everything to the state Supreme Court at least. I took one case to the United States Supreme Court. I was suing the Commonwealth about a constitutional amendment in '93. And one thing I learned was the United States Supreme Court forces the state Supreme Court to write an opinion. It's the only time I've ever gotten an opinion. It's the only case I've taken in the United States Supreme Court. So it was worth the filing fee just to get an opinion out of the Supreme Court. They're so elitist, they don't do it. But anyway, that's what I'd recommend. Get active. Give this document to everybody you talk to and say whether you read it. In fact, say, we'll be back. The other thing that I would encourage you to do is to get online and read these documents, pick out some subject that you're interested in, like the Supremacy Clause, as an example. You go to Harrisburg and they'll say, well, we can't do anything. That's federal, that's Supremacy Clause. We can't touch it. Baloney. Read my paper on Supremacy Clause, and then take that document and go to your state senator and your state representative and sit down with them. And the first thing you ask them is, and there will be 2 or 3 of you, maybe 4 at the most, and don't let them filibuster, all right? So you're in charge of the meeting. So you give them a copy of the document, and you say, have you read this? On the list is the date in which we handed it to them. They've all gotten it. And there's the date they got it. All right? They'll say no. Well, that's okay. Say, here's a copy. We'll be back in 2 weeks to talk with you about it. Read it, figure it out. Now, they're going to have some questions, and so you got to be prepared to answer the questions. Like any other sales job, you got to overcome the objections, right? And then when they finally said, yep, I got it. And you say, okay, from now on, you're going to vote and act according to what you just said is the law. And you can do that on a whole lot of subjects. That's why I write them. They're for you to take to your senator and your representative. You can write the governor or lieutenant governor, because we gave them to them as well. I used to give them to the attorney general, but they wrote me a letter that said thanks, but no thanks. But they wouldn't listen to him anyway. But the point being is, that's something you can do. And it deals with the fundamental cause of our problem, and that is those in government haven't read this document or the federal Constitution, don't study it, don't understand it, and they always say, well, I'm not a constitutional scholar. And they say, can we do that, Mr. Solicitor or Attorney or whatever? And my answer to that is, did they take your oath of office? Are they going to do your time in prison for violating it? Now, we got to get somebody to enforce that. That's the role of the sheriff, by the way. And so let's get involved. My pitch. There's a sign-up sheet over there if you're interested in getting involved in the Lebanon County or other county brigades, which is here to help us learn and network in support of this group, not in competition, but in support of, on lawful issues, on constitutional issues, instruct those in government to do their job, and then come up a way with enforcing it. And that's the sheriff. And the sheriff has the authority to deputize every able-bodied, well, it used to be men, 15 to 45. Now I think it's everybody. You know, women want equal rights, right? Well, you got equal responsibilities, folks. And I know a lot of women who shoot better than men do. I know my ex-wife was one of them. Point being is, I never messed with her. I mean, there's no way. Anyway, I wouldn't do it anyway. But the bottom line is, that's what we have to do. We got to get organized and learn and network, and there got to be a lot of us, unfortunately, because the law isn't enough in itself. Should be, but it isn't. And we have to get DAs to realize that they're not the top cops in the county, that the sheriff is, and we need to get the sheriff to do his job. In fact, you're going to have a new sheriff here, and that's a perfect opportunity to go meet with them and say, do you know what your job is? There's a document over there that talks about the duties and powers of the sheriff. So please, by all means, stay in touch, and if you have other subjects, I'd be glad to come back.